Hello and welcome to this Climate Salad Lunch and Learn with Bob Kramer on IP protection and law. My name is Charlotte Connell, and before we get started, I'd like to acknowledge the traditional owners of the land on which we meet, and for me, that's the Gubbi Gubbi people, and I pay my respects to their elders past, present, and emerging. I'll hand over to you now, Bob.
Thanks a lot. This first slide is a bit of a joke, but I'm trying to make a point that there's such a thing as bad intellectual property and good intellectual property, and you don't really go to your trademark attorney, for example, to find a good logo or saying, but you do go to them to help figure out what's enforceable. So I'm trying to make that distinction there. But I will explain what I'm talking about through the hour today. My goal is, let me just make sure I can get through these, move forward.
And Bob, I probably should have asked you at the start, would you like people to ask questions throughout, use the chat, or wait till the end?
Yeah, feel free to ask questions as we go. I don't really have a chat. There is a chat function. Let me pull that up. And or just turn your mic on and ask a question. And then there should be plenty of time at the end to talk about that. And I've put my contact information, or you've put my contact information out there, so feel free to reach out to me afterwards.
Wonderful, thank you.
As you mentioned, my name is Bob Kramer. I'm an intellectual property attorney. I've practiced about half my career solely in the United States, and the last half of it both in the United States and here in Australia. All the work has been intellectual property work. Some of it has been antitrust, or what we call here competition law, unfair competition issues and so forth. But most of that work has been working with very large companies in big intellectual property litigation. Some of it has been with startups. A lot of it's been with startups who have become bigger companies. And so I've worked through that transition from early startup to companies in the 3 to 10 year range, helping them get better policies and procedures in the company, especially around intellectual property, so that they can transition to be a much larger company. I worked in-house for about 7 years at a technology company in Silicon Valley, which was about a 10-year company. So just a little bit past the startup. They like to call themselves startup, but they weren't anymore. But they still had all the policies and procedures of a startup. So that led to lots of litigation and a lot of experience in that. So my hope is to convey some of that understanding and knowledge to you today. If you've talked to an intellectual property attorney here in Australia, what you've probably seen already is that here in Australia we separate out the attorneys from the solicitors from the barristers. So you might just be talking to somebody who's really good at drafting a patent or a trademark, but not necessarily somebody who's good at litigating them or enforcing them or licensing them, or showing up in court and arguing in front of a jury or a judge. So in the United States, we don't make those differences. That doesn't mean everybody's good at all of that, but I've got at least some background in doing all of those things. So I'll try to pull from all of that to give you useful advice as well. And I should just mention, I work for a firm, you'll see it up here, called Finnegan. There's a much larger name to it, but for branding purposes, just call it Finnegan. It's a global intellectual property law firm based in the United States and Europe. I'm the only person here in Australia. I'm qualified to give legal advice here, but we tend not to practice here. We work with other law firms here in Australia. So I've got a good cooperative relationship if you need referrals here. But most of what we do is sort of global IP strategy, and there's no reason we can't give that advice here as well. Okay, I just pulled this off the Climate Salad website, and I'm pointing to it for a few reasons. I wanted to point out there's at least 171 companies now in Climate Salad. What that tells me as an IP lawyer is there's lots and lots of room for making mistakes that compromise your intellectual property, because you're working in a cooperative incubator-like environment where you want to share what you're doing and you want to get advice from other people, but disclosure of intellectual property beyond non-disclosure agreements and beyond people who need to know within the company can risk losing IP. So there are some risks associated with it, and I'll try to address some of those today. Also, the median age of a company is 2 to 3 years here, which tells me that we're in the startup phase, and a very quickly growing phase, trying to get another 50% of the employees currently employed in the member companies. So what that says is we're a startup in a situation where we have startups that are greatly outpacing in growth the internal controls that are likely developing alongside that. And I made reference to the company I worked with in-house before, and even at 10 years, they were quickly outgrowing still the internal procedures that they needed to keep themselves safe. So it's not something that's really going to change over the next 5 years for you as a company, but it's something to be wary of, and I'll talk about that. At the bottom right corner here, I see that the Progress is intending currently at about $100 million in revenue, but trying to increase that fivefold amongst the companies in the next 12 months. What that means is some of the companies here are likely to become targets for intellectual property allegations from other companies. And I want to talk about that because as you start to be a deep pocket, you really want to be in a better situation to deal with those. Okay. I'm going to refer to the companies here generally as startups, and the problems are generally startup problems that you're likely to have. As I referred to before, the problem is that the internal controls, the business processes, the policies and procedures are not growing at the same speed that the technology, the client outreach, the employee growth are growing at. And that's because it's much easier to start and run a company these days than it ever used to. We're not talking brick and mortar usually, and the zeros and the finance and the HR portals can grow very quickly, but the policies and procedures and the understanding for what is needed and why don't grow as quickly usually. To the extent startups get involved in intellectual property, and I saw that some of you are, and there are a few companies in Climate Salad that are clients of ours, but usually what happens to the startups that are involved in IP early is they get a tick-the-box mentality on IP. I know I need IP, I just need to go to somebody, get something filed, and then I'm on track. But that's not taking the right approach. That means the IP is growing organically, which sounds like a good thing, but it's not, especially in the climate area. And it's growing in a tick-the-box fashion rather than thinking strategically and long-term about what might be useful, what the risks are, where the competitors are, where the markets are, and rather than just filing IP, we can be a lot more strategic about it, filing less, maybe even spending less money on the IP, but doing the right things at the right time in the right places so that we don't have a one-size-fits-all approach, we have a strategic approach. The flip side of that is especially in markets like Australia, where it is a startup market compared to a large manufacturing market, we tend to have IP services that match that, which means a lot of the big IP law firms and attorney firms have really followed a race to the bottom in trying to get IP provided as cheaply as possible to companies who are asking for it as cheaply as possible. And the quality of the IP sometimes drops with that. If you've got any interaction with some of the firms here, it tends to be privatization of the law firms, and they've all more than half the market now is serviced by attorneys and lawyers who are working in a firm that's gone public. And so what they're trying to do is increase profits by increasing the number of filings they have per person, rather than really trying to provide each client what that client needs. What you'll find in European and U.S. markets, in contrast, where there's a lot less of that approach, is an emphasis on having firms that really try to provide the best service for their client, and they use their big litigations to fund outreach to startups who don't really make law firms very much money in a proper model, but may grow with those law firms over time. So that's very much our approach, and the approach of a lot of other law firms you'll find overseas, and a few firms here as well in Australia. But by way of example, Finnegan, the first attorney working as an IP attorney at Google was from Finnegan, and they've been a long time client of ours. They obviously use a lot of other firms at this point, but that's sort of the business model that you'll find overseas and in some of the firms here in Australia. And I think for a startup, you really want to look for somebody who's going to grow with you, but also have all the capabilities to offer you now, and not somebody who's going to learn on your dime, so to speak. Okay, so if done right, the IP services, I haven't talked about what they are yet, but if it's done right and it's provided in a strategic way, there are a lot of benefits to having IP and getting IP advice. The key one here is the one I've highlighted a bit, which is identifying and minimizing risks and avoiding pitfalls, because it's something that you need to do very early as a business, even if it's going to take some of your time and some of your money. In addition to identifying the risks from other companies that they're providing, it helps you identify timelines for when you're going to lose rights if you don't file by those timeframes. It'll help you identify a brand and a brand name that's going to be able to grow with you, rather than one where you're going to have to rebrand before getting much bigger because someone's going to sue you, for example. So a lot of other benefits here I've got listed out. Happy to talk about any of those, but it would take forever to go through those. If it's done wrong, you've got a lot of big problems, and I just wanted to talk about a few to scare you into thinking about doing something if you haven't done it already. Intellectual property is a right to exclude somebody else. It's not a right to practice your own invention or to use your own trademark. And that's a really difficult concept to understand, I think, if you're not experienced with that. The goal of IP is to, for most IP, get a registration from a local government, and IP is local, meaning country by country, and get a right that either gives you a time to market advantage, because it means that somebody else can't do the invention that you've created, or you get some additional leverage in the licensing that you're going to be doing or the negotiations that you're going to have as a company, or it's a way of protecting that information and getting it to the company away from the employees or away from the contractors and so forth. But there are a lot of deadlines out there, and there's a lot of strategic considerations. And if you don't file the right type of IP in the right country, targeting the right competitors or competitive risks, then that IP will exist on paper or exist electronically, and you can brag about it, but you're not going to be able to assert it or enforce it against other people. And that's why we say 99% of IP is not worth the paper it's written on. And the only way to ensure, a lot of it's guesswork because you don't know where your competitors are going to be or where you're going to be over time, but there is a lot of strategy in it, and you can try and get your IP better targeted towards something that's useful for you, for your investors, and your long-term strategy.
Well, I might just jump in and ask a very quick question, if that's okay, and please feel free to take this one on notice if it's answered on it. The international aspect of IP protection, interesting, I think, to all of us. As a startup, if you have IP protection in your first market, but then you only seek that later in other international markets, it would be just great to get an understanding as to what the right strategy looks like. Undoubtedly, one where you protect that IP in every country is ideal, but obviously expensive. So it'd be great if you could talk to that or touch on that at some point.
Okay, I think that would fit in really well when I start talking about the different types of IP, if I can defer that question until then. And I think that's an extremely important point because in this tick the box mentality, what happens, a lot of startups file their trademark, and a trademark you can extend later into other countries. The only risk is if somebody else starts using it before you do. And in certain countries like China, where that might be of critical timeline. But there are other types of IP like patents or design rights, where if you don't file them within a certain period of time, you lose them. And if you don't extend them to other countries within a certain additional time that you have, you lose them. And so that's really what we're going to talk about. And that's why I'm pushing you today, and I try to push my startups to have an early meeting with an IP attorney and just explore what those are as they relate to you, because IP is different for every company, and so there's no uniform answer to that question. Okay. Thanks, David. There are special risks to startups in the co-working space. I referred to those earlier today. Inadvertent disclosure of your IP is the big one, because you're sitting next to somebody in a startup hub, or virtually you're online. Somebody's recorded it, and there's evidence out there that you told people not in your company who had no reason to know the information that this is how you have a new technology and this is how it works, and you're maybe offering it to sale to a VC or for crowdfunding or whatever it is, and all of a sudden you've lost the ability to file a patent or design right on it. And there are grace periods and different types of public use that count or don't count, and again, they vary widely by country. And if you're facing those risks, and that's why an early assessment might help you, knowing what those deadlines are and knowing what to say and not say during those startup and co-working meetings may be of critical importance. Another thing that startups often get engaged in, which creates problems, is standards, especially in the climate space or the electronic space, where you need a bunch of companies coming together and agreeing on standards that'll work across countries or across the earth. The risk is those organizations want to minimize the cost to everybody of working the new technology, and so they all throw their IP in together and agree to have these standard essential patents or technology-wide standards, and then all the companies that are participating in those could be agreeing, whether they are signing a piece of paper or not, to license their patents for free. And Europe in particular is particularly harsh on that. It's an issue I've litigated for 15 years. And it's counterintuitive to startups in particular. So you just have to be careful as to what you allow into those types of arrangements and what you don't. There's lots of other issues. If you sell your technology early on to somebody, you may be limiting your potential license rate out to all companies after that. So you have to be careful. Likewise, if you license into a particular part of the technology market, you may be working with financial advisors or business strategists that help you figure out where you're going to make the most amount of money, but you may have a first sale doctrine or patent exhaustion doctrine, which says once you've licensed at one area of the market, you can't license certain downstream people, and that means everybody else gets to use it for free. So even if your business plan has you making money later on because you've seeded the market early on cheaply, there are risks to never getting any money later on. The last thing I just have here is risk of litigation. It's probably, as a startup, not something you have to worry very much about, maybe on the trademark side a bit. But as soon as you start having funding events, especially going public or a big VC putting a lot of money in, that's where your competitors who may be watching you and you may be infringing and not even know about it, that's when they're going to hit you up, because that's when you're going to pay anything to get rid of the issue so it doesn't affect your valuation. So especially if you're looking at one of those events, you want to be prepared a few years ahead of time to head off those risks. On the flip side, even when you're a really large company and you're looking to pivot or sell your company out, and AOL is a great example of this, you may have a lot of patents or a lot of technology, but you might benefit from having a patent attorney come in and look at your IP and refashion it, file some new continuations if that's possible, and turn around and increase the value of your IP and your valuation. And AOL's the big example to date. It was the highest per patent sale price at the time. It's something that we work with them on quite a bit to refresh their patents and make them better target the ways in which they were being used, even though they were quite old patents by that point. Okay, so I've got this justice balancing scale here, and the only point I'm trying to make here is startups have a lot of, or don't have a lot of things that big companies have, and that really creates an imbalance in the use of intellectual property amongst many other things. And it used to be 20 to 40 years ago, the IP model for the IPs and the Microns of the world is buy as many patents or file as many patents as you can, and then when you get into cross-licensing, you just say, I've got 50 patents that you might be infringing, you've got 3 patents I might be infringing, so you owe me a net benefit, or a net license rate of X. Other companies like IBM, once you got over $1 million in money, as was a while ago, they knew that they would come after you for a certain licensing fee. That was the old business model. We've gotten a lot better at targeting intellectual property to companies that are using that intellectual property, and so the licensing has gotten a lot better targeted. But in the last 3 to 5 years, 5 to 7 years, companies have gone on a IP buying spree again. And I've got that here in the 2019 timeframe. I think that continued for another year. Maybe we've had a bit of a drop off due to coronavirus, but we've had a huge filing increase as well, and some of that has been in the climate space. And the reason for it is a lot of employees are moving out of the old big tech companies and moving into climate technologies. And that's why we're seeing growth with entities like Climate Salad. But they're bringing with them a lot of innovation and desire to come up with new technologies and new ideas that are going to work not just for increasing click-through rates or advertising, but doing something technologically that's going to save the planet. And they are filing patents in the area, and it's the big companies that are filing or buying the smaller companies that are filing some IP. So how do we help rebalance that scale? It's not just doing the same thing the big companies are doing, because the startups can't buy a lot of IP. They can file some, they can be very strategic about it, but they can't just buy a bunch of IP. And the brute force method just doesn't work for a startup. I've got some statistics here from patent filings, and I think these are useful if you want to go back and look at them later, but what I've tried to do here is collect from the OECD the records for the last 20 years of granted patents. This is limited to the US Patent and Trademark Office because most IP work is US or European focused. Most people file in the US or Europe, if anywhere. You might file, for example, as an Australian entity in Australia, but if your biggest market is going to be the United States or Europe, you file either first or definitely in the US and Europe. So the numbers are the largest here. They're most representative of what's going on globally. So these are global grants of patents in the United States. The top row of numbers is just total number of patents that are granted every year. So you see there's about 350,000 being granted in recent years. The row down from that is environment. We see about 35,000 patents granted. About 10% of the patents that are granted have some environmental aspect to it, as the OECD is breaking that up. The next, all the rest of the rows are broken down by different types of environment technology. It's their rankings, not mine. I've highlighted the years, I'm in the way a bit, that are the highest within each of these categories. But if you've ever worked in the patent space, you'll see that all the technologies are broken into different technology buckets. And so this is not an art, it's very much a science of looking and seeing where the technology in those patent filings fall. The greatest...
Oh, sorry. I just thought I'd jump in there, Bob. Since the SEC made it mandatory to disclose on climate-related risks, have you seen a pattern of this go up? Like, I know the data just ends there at 2020, but...
Yeah, so we don't have 2022 numbers currently. The 2021 is out, and they're roughly on par. There's a slight drop in some of these categories, and I think the overall number has dropped. I don't know. I think the number has maintained the relative proportions, but yeah, they just haven't put out a finalized number that I saw yet. But I think it's generally holding. We see some trends here, not just in increasing, but I think one of the things that has happened just behind the scenes to complicate it, why I'm pausing here, is in Australia, for example, the ability to file patents in business method areas and computer algorithm methods have dropped off quite a bit. They dropped off in the United States as well, but they've started to pick up because there's been much better advice and in the patent office and in court rulings as to what you need to do to get those. And so people move how they characterize their patent claims around and from category to category in order to try and maximize the likelihood of getting a patent. Same thing in terms of some of the different patent art groups are quicker at granting patents or more likely to grant a patent. And so people move things around. So you can't rely too much on the breakdown between these groups at a detailed level yet, because that's changing at a much greater number than the number of patent filings proportionally. So you sort of have to stick with this at a high level, I think, until we have a few years of trend recently. I apologize for that. But I have another slide that's going to compare this, but what I wanted to point out was roughly 10% in the environment space. There's a rough breakdown, but the majority tend to be, as you can see, I put it in the red color, the energy generation and transmission space, the environment management, and transportation spaces. And that's reflecting who's filing and where they see the value. The leading companies, Mitsubishi is, I think, double the next highest one. GE is in there, and then it's sort of a long, slow tail breakdown from there. Patents are good at this point for 20 years, so if you collect the total number of patents that are still effective, again, in the environment space, it's a little less than 1 million patents. And that just keeps moving as a tail as we progress. Now, to make this a little bit more relevant to Australia, what I've done in this next slide is just take the total number of patents that are granted to assignees in Australia. So it doesn't necessarily say the company is located here in Australia, but they're representing on the patent grant that they're an Australian company that's the assignee of those patents from the inventor company usually. This is really who owns the company in the year that was assigned to them. And then all I did was take the number and divide by the total to get a percentage. And then I've highlighted the years in which we were the highest percent. I might have got it wrong, but I tried to flesh that out. But to do a fair comparison, most patents are filed by entities in first world countries. And so as a percentage of population of the first world countries, we have 2.14% of the population. But if you look at these percentages, that's well below that. So we're batting well below our weight in just patents per person within the country. That's not particularly surprising because patents usually come in countries where there's a manufacturing benefit, and we just don't have a lot of manufacturing. So the Asian countries tend to file a lot more patents. And then after that, it's where it's developed, and so that tends to be the United States and Europe. And we should be in equal numbers with those countries. The problem is a lot of the Asian countries that have high manufacturing tend not to be first world countries. And so this number is probably actually worse for Australia than it is better. What that means is even though we like to tout that we have a lot more research papers coming out per person, and we like to say even within the technology space that we have more R&D spend or technology development in Australia, we're not filing to protect IP in those areas. In terms of the top 1,000 patent assignees in the United States, and remember, everybody files in the United States at one point if they've got technology that they're pursuing. We've only got 5 companies that show up in the top 5. One of them is a patent, not quite a troll, sometimes a troll, Kia Silverbrook. The others are sort of manufacturing product companies or CSIRO, a big conglomerate that's filing in a lot of different areas. So we don't have the big GEs in the world, we don't have the big Mitsubishis of the world, and so our numbers are going to be smaller just from that. That said, I've seen a number of different people assess I'm blocking it here, total amount of estimated yearly deficit that companies in Australia pay to use IP for companies outside of Australia, and it's calculated roughly at 3 billion Australian dollars. That's where I really wanted to get with this, which is even if you think you don't need IP, and even if you don't, for defensive or offensive purposes, there's going to be a time, if you're a technology company or a branding company, where you're going to be paying other people to use their IP or using your IP to defend yourself against their allegations or to try and cross-license. And this number reflects the fact that we're doing poorly here in Australia. Some of this is because we're not litigious here, and that's fine. but we at least need to be prepared for when other people are litigious, especially as our products and services grow into foreign markets where we're going to get sued. These numbers do not reflect the negotiating leverage that we don't get because we don't have IP, or early sellouts of our companies to larger companies that buy us when we maybe didn't have to sell out as early because we might have IP that might get us more investment or more leverage. So we could be doing better. That's not to say you're not doing better, but I think we could all just do better here. Now, it sounds like I'm just trying to sell IP services, and I am in general, but it doesn't have to be me. It has to be somebody. And the cost of IP can be expensive. It can be cheap. It depends on what you're doing. But the most important thing is to talk to somebody early, and that can be the cost of coffee, or if you want to get a little bit more time with somebody, offer to pay for lunch for that person. Call up an IP attorney or email them and say, I've got some questions. I might be a client, I might not. I might just want a referral. I don't know, but I know I don't know something, and I just want to talk to somebody about it and get on somebody's list for when it might be relevant. Can I take you for coffee? Can I buy you lunch? I've written a few articles on this exact point and some additional things about what to consider and what additional information you can get. They'll be in the slides, and you can click on those links. The goal is to set yourself up for an IP strategy. And the more strategic you can be, the less organic and the more strategic you can be, the more likely it is that you're spending only the money that you really need and want to spend at the right time. And you can come up with a plan to spread that money or those costs out. So if you come to an IP attorney because you've been sued, that's the most expensive thing. If you come to an IP attorney before you get sued and before you have a trade name, that's the cheapest way to do it, because you can say, I want to file this trademark today, and then I've got 6 months to extend that into other countries. If I filed a provisional patent, I've got a year to file a standard patent, and then I can go through a PCT process, and I've got 30 to 31 months before I have to really start spending a lot of money, to David's point before. And that's what you should be looking for. How to spread that out, how to spot risks, and work out everything in between. So this is a slide I mentioned before about the different types of intellectual property. I'm not going to go through them one by one here because I've got other slides to deal with that, but I've sort of ranked them in terms of what we think of as the most important to least important. But it really just depends on the type of company you are, whether you have technology, whether you're playing in a branding space, and so forth, whether you've got a lot of trade secrets, and one thing might be a lot more important or lead to more investment or otherwise. So even though we say utility patents are the big bad boy of the IP space, that's because they cost the most, but it may be that a design right at 1/10 the price can bring you just as much safety. I'll spend 5 minutes walking through the different types of IP here, and add into David's point costs and timing and so forth as I go. Here I've just broken out for a hand drill. You can have a design patent and a utility patent on a drill. The design patent is trying to protect the overall look or design of the product, and the utility patent protects all the functionality in your invention. So how things fit together, how the improvement in tweaking something creates something that's more functional or useful going forward. And so on the utility patents, you'll usually see in the figures numbers put to everything, so you can refer to them and claim very specific functionality addressed to very specific parts. The design patent is very much about the design, and so the protection is narrower. You're not protecting the functionality regardless of how it's designed, or you're protecting just the design. But for example, if you've got an espresso, you don't care necessarily about the functionality of the coffee press. You might file a patent on it, but you know everybody else is going to be able to design a new design on how they're going to do it. So you create specific pods that only interact with your Nespresso machine in one particular way, and then you get a design patent on the interlocking capability of those, and that's how you stop competitors from doing something that could either otherwise do very cheaply and easily. So they each have their own value. A utility patent everybody talks about IP in terms of US dollars because that's how we measure costs globally, and all the firms will give you things, unless you're here in Australia, in US dollar costs. So just using that, a utility patent will cost you around $15,000 to draft and file the first one. A design patent could be $2,000 to $3,000 US dollars to do for the first one in the first country. The utility patent, then, as you go into each other country after that, depending on how you do that, might be another $3,000 to $5,000 more if you have to translate, and then depending on the size of your patent, how many pages and words and so forth in claims. Whereas the design patent would be sort of $2,000 to $3,000 US per country. So you can see you can get a lot more design rights out there for a lot less money, but you're not protecting the functionality. And what I'm going to say near the end is you want to be able to do both depending on your technology and your competitors and everything else. Just to beat a dead horse here, here's another example of design rights on the left and utility rights on the right for a Herman Miller chair. They've obviously changed the design of the chair over many years. It's actually the one I'm sitting on. You can't see because of the technology I'm using. But you can either claim the functionality, and it doesn't matter how people design the chair because you've got a patent on the functionality with a utility patent. You can also protect the weave of the chair and different aspects of functionality, whereas the design on the left, you can protect different aspects of the design, and different countries will let you file those applications in different ways, either as one big one with a lot of different designs all put into one application, and then you file continuations off that over a 15-year period and save a lot of money because you only file when you need to, versus countries like New Zealand where within a year of filing you're going to have to separate them all out, file them all as new designs and spend all that money up front. So the strategy, because every country implements in different ways, requires that you have somebody who knows all the ins and outs of all the different countries that you care about, or will be able to figure that out for you and come up with a plan as to where you need to spend money up front and where you don't, to protect for the countries that you care about, not just the technologies. Google has protected, by way of design patent, their search bar, and in general, and again, every country is different, if you see dotted lines, the dotted lines refer to things that are not protected in the application, and the bits that are solid are they're attempting to protect. This one's protected in the United States as of 2006, and it expires next year. In the description for the patent application, you can see, I've just highlighted in red here, that they're also pointing out, they're not claiming it as part of this application, that they have trademarks on this page and a copyright to the overall reduction of work to a medium. I'll talk about copyright in a minute. So the point in that is that you can have overlapping rights here, design rights and copyrights and trademarks all on the same web page. A lot of people think, well, you can't really protect anymore because everybody knows is using sort of search bars and everything else, but we're still getting a lot of applications and registrations for new ways of presenting information on screens, whether it's in apps on phones or iPads or on desktop monitors. And so in different countries, we have to protect those things in different ways with different applications. If you just think I've got a design, I'm going to protect it, it's a lot more complicated in initial analysis than that. The design patent can last 5 years to 20 or 25 years, depending on the country, and there are renewal costs and annuities and stuff like that you have to file and pay for. So again, if you come up with an IP strategy, that'll help you map out those costs over time. Okay. Talk about trade secrets before I get into trademarks, because as a startup, you're likely to have a difficult time balancing what it is you want to keep as a trade secret that's confidential to you and what your employees know from companies they might be coming from, or if you lose employees, how to protect that information so it doesn't go to other people, and patents. And there's a lot of overlap between the two, because a patent is a public disclosure of your technology in order to get a 20-year a right to stop other people from using it, versus a trade secret, which is keeping something confidential so nobody else knows about it. And if you haven't thought about that early and you disclose or you put it in a patent and it gets published, then you've lost the ability to figure out how to be strategic and protect your IP and protect your competitiveness right from the start. So there are a lot of different types of trade secrets. I've got some listed here. The algorithms, the software coding, the business methods can all be trade secrets, and they might be your secret sauce for how to get carbon out of a particular product or out of the air. You may want to license it out to a whole bunch of people, which means you have to put it into a patent, or you want to build your own products and you want to keep it secret, and so you want to keep it as a trade secret. So having an IP attorney give you the ins and outs of what you'll be able to protect in which countries, and figure out that line can be very valuable to you. To protect something as a trade secret, though, you have to actually take steps to keep it secret, not just confidential within your company. And again, an IP attorney will help you figure out what you have to do. Just by way of example, Cadbury has gotten a utility patent on the method for making their dairy milk chocolate, but they were also able not to disclose some of the particular process details that gets it the exact texture that they want it. And the texture is largely what sells the product after the brand name. So there's a way of balancing those two that can be very valuable to you if you're in that space. Okay. Just for completeness, a copyright is when you reduce anything to a medium. So if you've got instructions in an instruction manual, putting that into instructions, whether it's on the computer, in a software file, or whether it's used to make something in 3D, all of those can be protected in copyright. That's the general idea, but as you go from country to country, the same type of right is protected using different intellectual property types of laws. So China will be a bit more liberal in using copyrights on product designs than Australia would be. So you might protect something with a trade dress right in the United States that you protect with a design right in Australia that you protect with a copyright in China. And if you have an attorney that doesn't know the difference between those by country, you're really selling yourself short. And the problem is you're never going to know that you sold yourself short because you don't know what you don't know. So that's why it's valuable to get somebody who's good from the start. The other big thing that you can get from a strategy plan here is what we call perpetual rights. So a utility patent lasts for 20 years. A design right is usually 5 to 10 years, and it's in renewable blocks up to 15 to 20 or 30 years, depending on the country. But then it's over, and then everybody else gets to use it. So how do you stop that from happening if you've got something that you want to extend beyond that? If you're in the pharmaceutical space, you come up with a Latin name for your drug, and you come up with your brand name for the drug. And then when the utility patent expires on your drug, you've still got your brand name that you've built up a bunch of goodwill on, and you can keep using that, and people are going to buy the brand name because they trust it. So you're not preserving 100% of your market, but you're keeping a much more of it than you would with your utility patent. Design rights, the same thing. Coke designed a bunch of different types of bottles back in 1910s, 1920s. Here on the one I have on the left is one that they registered as a design right in the 30s. And that patent lasted for 14 years at the time. And then it was over. 51, I guess, is when it was over, yet they still have rights and still prevent people from making designs like that bottle. And what they did was, if after enough time the market comes to understand your product as being associated with you, that's a trademark or a brand. And if you can take that and prove that has what we call secondary meaning in trademark law, then you can file a trademark application on it, which they did on a bunch of different types of bottles. Here in 1959, they filed it in this black and white image on something that they first started using in 1916, and they're still using today. So even though they had a design right and prevented everybody else from using it early on, they're now relying on trademarks to do that in a way that you can't when you first come out with that product. And it's just a particularity with different types of IP in different countries and how you piece those all together to preserve your rights as long as possible. Now, in the years I worked in Silicon Valley, it was fairly commonly known that the most valuable IP that a lot of the big tech companies had were their trademark, their brand. And that's because if you're Google, you can have a lot of different products, but the reason people keep using those products and trying the new products and putting their data into those new products is because they trust the brand. And as a startup, we tend to think that our brand isn't that big a deal, but it is, because people will copy it, and you may be copying other people's brands without knowing it. But as you start to grow from that sort of small to mid-sized company, it's that brand that's going to carry you forward from your first product to your next product, so that Lightning, even if it doesn't strike twice, you'll still get some additional money by keeping your customers in the goodwill of your company. Angry Birds, by way of example, you can't trademark, at least in the United States, a book name or a movie. But if it's a movie or a book name that you're using over and over, like Harry Potter, and you have different specific sub-names for your product, then you can protect that name. So early on, there was a Finnish company, I think it is, that is Angry Birds. They went out and trademarked just the characters that they had. But as they got into, and it was a game product, but as they got into movies, they realized they didn't have movies protected, and sadly I've covered up the trademark here, but they have a TM, not a R registration. They didn't have registrations in 2016 for movies. They just had it for games and other things. So if you think ahead about what your product development is going to be, you can file early and stop other people from coming into that market and trying to claim rights, like the two on the right here, or in the middle, I guess, Angry Chicken, for example, and I can't remember who the first one is, but they had to go to the trademark office and fight the potential trademarking of these other products that were trying to trade on their goodwill. And so that's what you want to do. You want to build a penumbra around your brand that prevents anybody else from using anything like your brand on any product like your brand, not just your exact trademark on your exact products. And that's what trademark lets you do. Likewise, you have to think sort of long term. St. George, back in 1932, filed this top right image as a trademark here at IP Australia. And the concept is St. George fighting the dragon. But that concept goes back at least to the 2nd century, if not back to ancient Egypt and Greece, of St. George offering to defend a town against other people if they will convert to Catholicism. So it was very much a live or die on my sword, I will protect you type image, which is not what St. George was going for, not in the 1930s, definitely not in the 1990s when they filed this other cartoonish dragon on the left, not in 2009 when they filed this other trademark for the one that's most common right now, the St. George. And they haven't yet filed a trademark for the 2017 fuzzy, friendly creature, but they are trying to describe their services and their brand to their customers now as St. George, still using the dragon, but not as the enemy that needs to be slayed, but as the thing that gives us a boost of confidence to get out there and start doing something. And the point I want to make from that is your brand can evolve, your interaction with your customers can evolve, and with the market it can evolve, and you can use bits and pieces of your brand to do that. But you can't do it if it's just a word mark, and you can't do it if you haven't protected it. I'm going to talk about this just a little bit more detail. As you're trying to figure out what your brand is, look for something that makes you unique from the market, not just a fully red shoe, but a red sole shoe. That's why people buy it. That's why people pay money for it, and build your brand around that. File a trademark, as they did on that. Here, I'm just making a little fun of Climate Salad. The trademark prevents others from using Climate Salad or any trademark in a manner other than just in a descriptive manner. So you can always refer to the company even if it's trademarked in a way that's just you're pointing out that you're referring to the company, or you can use it in a nominative, meaning a fair use way, because it's just easier to refer to the company that way. But what the trademark registration allows you to do is to prevent somebody else from using it in a way that you don't agree with. So they can't just put your brand on their webpage and say that you're somehow associated with them. Likewise, as you're putting on your page all the other companies that you work with or that use your services, you need to go out and get permission to do that. And an IP attorney can help you spot those issues. In terms of branding, I've got a bunch of slides here that I can't go into in detail, but they're here for your use. As you're trying to brand, think of coined, fanciful, and arbitrary marks, because they're going to be the strongest ones, whereas descriptive marks or suggestive ones will cost you more and harder to enforce. And I've put out here things that are coined and fanciful. They have no relationship to the goods or services and no relationship to anything that existed before. Those are ideal, and you'll want to file those as a word mark and a design mark. The arbitrary ones mean something like camel and apple, but not in association with goods or services that you're offering. Suggestive marks suggest what it is you're doing, but don't actually describe them, so you have to think somehow and make that connection. Chicken of the sea is actually kind of funny. The problem with these types of marks is chicken of the sea is great for tuna, but if you wanted to expand your brand, you can't really do anything else with it beyond tuna or a few other things, because the joke's gone. Descriptive marks are the worst. They require, if you've got a descriptive mark, that you have to prove that your customers, that the market associates it with you, and that takes years and years of proof. And you have to do that in order to get a trademark to stop other people from using those marks. So when you think about your brand, just think broadly. It could be the design of your packaging. It could be the color. Apple's protected the look and feel of their store. There's a lot of different ways to identify what your brand is. When you have a word mark, think also of doing interesting things with your logo, like building the New Zealand line of the country into the percentage sign, or the arrows into FedEx and Amazon. Whatever you do, avoid boring. I've been on a big tear with my clients in the last couple of years to stop their boring trademarks. If you look it up, mediocrity and boring trademark on the internet, you can find this video, and it's quite funny, but it takes a while to get through. We helped Subaru go through this process, and they went out and analyzed with their customers. Their customers love them, and it's something that people who drive Subarus love them, and so they went and built on that and actually filed trademarks on on the word love in association with cars. And it's quite helped, and it's one of the most successful advertising campaigns they've ever run. They got much better. I don't know if anybody knows what tech company this is. When you look at it, some people know right away, some don't. Does that help anybody? Right? If you've got a good logo, you can play off the color scheme, the size, the relative size of those, and people start looking for your logo in different places where they'd expect it. And Google's done that quite effectively with their colors and so forth. You can also then play with culture and things that are going on. If you've got a logo in particular, you can do things to that logo that help you bring in goodwill and people like you more. And it's a way of distinguishing yourself and getting customers that other people who have boring trademarks can't do. You can also, this is COVID, some of these are real, some aren't, but it's a way of saying you understand what your customers are going through and be safe, and you're on their side. The other thing it does is it really creates this penumbra around your brand that makes other people uncomfortable when they see things that don't fit right. Crest in the United States, I just don't have the skills to have modified this, but it's like Oral-B here, it's Associated Company. When you put your brand on other people's trade dress, or they put their brands on your trade dress or whatever, if people know you and they have goodwill, they just, it doesn't feel right, and it helps you protect yourself in your marketplace. So just as a mental exercise here, which of these brands to you do that? Help, maybe you've got a good experience with Westfield, so you're more likely to go into a Westfield, but these brands, some of them are okay, some of them aren't, but like Qantas, they have the Feels Like Home logo, which I think is amazing, but they don't do it very much with. They should trademark that. but a lot of these brands don't. Here's a lot of your brands. As you can see, some of them are just industry terms, and it's very hard to protect an industry term. It's hard to pay for and get trademarks and fight other people off, and then you'll only have very narrow protection in those. Likewise, common symbols of hearts and things, there's a lot of other ones out there, so your protection is going to be narrow. Things that are funny plays on words but are phonetically similar to what it is you're doing, like if it's straw for straws, then you're going to have a hard time protecting that, especially in foreign countries that just do phonetic equivalents. So just think about a lot of those things as you start building your brand up, and make sure it's something that can grow with your brand. One of these is a climate salad company. I just pulled a bunch of similar trademarks off of IP Australia, and it might be hard to protect that mark. I'm not saying any of these are in the same goods or same services area, but it's just harder to distinguish when you don't have something that can grow without bumping into other people in the future. I put some stuff up here. Searching and clearance is useful for trademarks, but it's costly. So again, a big IP strategy thought up front can help you figure out whether it's worthwhile and whether you need to do that or not. So what types of IP? It really just depends on your type of company. You can't have them all. You can't pay for them all. Trademarks are cheap. Utility patents are expensive. Trademarks can last forever. Utility patents only ever last for 20 years, but there are ways of extending them with new patents. It's done a lot in the pharmaceutical space. So you can't know what to do with your company until you've talked to somebody. You can't do everything. If you can, that's great, but there's lots of different things you could do. And so the best thing to do is, for the price of a cup of coffee or a price of lunch or golfing or sailing, Mick, thank you, just call somebody or get a referral to somebody. It doesn't have to be me, but talk to somebody early and help them, have them help you walk through things and spot issues so you can move forward. Sorry, I didn't leave much time for questions. I'm happy to stay on as long as you want, but
Bob, that was really incredible. I actually just looked at the time and I was like, oh, wow, it really has been an hour. So thank you so much. It's been incredibly informative. I thank you for your generous time and for staying on. I'll have to throw it open to some questions. I know I have a few, but this is for you, the founders. So jump in.
I know I didn't fully answer your question, David, but I got some of it. You want me to talk more about it?
Unfortunately, Bob, I've got to run till 1 o'clock, but I will watch the recording if you want to talk to it further.
Good.
Bob, I did have just one question if no one's jumped in. Sometimes, you know, in those early embryonic stages of a startup, sometimes founders don't want to share their pitch deck unless there's an NDA. It's still just an idea, or what's your advice?
The advice whenever you ask a lawyer, solicitor, a legal question, the answer is it always depends. And if you have a lawyer sitting next to you and they could look over the NDA and look over the technology and look over the company you're sharing it with, then you can fashion the three to get to the best place you can. But if you're meeting with a big tech company, they're not going to talk to you if you've got an NDA. Same thing with a big investor sometimes, or VC, they won't talk to you. So then the question is, how do you narrow down your pitch deck so that you're giving them enough of what you can give them without risking your IP? Or if you can't do that with your technology and your market, file through your IP first to protect it, or get a provisional application in there if it's a patent, and at least protect something before you lose it.
Callum had a question. Go for it, Callum.
Thanks so much. Hi, Bob. That was an awesome speech. I really enjoyed that. Learned quite a lot.
Great.
We've got a title, looking at your chart, your graph there, we've got a tidal energy system. So we're actually in the category of generating electricity from the tide. But looking at the patents and having one for design and one for utility, I'm not sure that we have both across our key product features. So that was really fantastic, because I think I have to go explore with our patent attorney whether we've got those patents enabled yet or not.
That's great. You may have dates that you've passed where you just can't file anymore, but if it's useful, sometimes a slight redesign can give you the ability to file, for example, a new design right. And if you're past all of that, sometimes in the fashion space, for example, we'll get to the point where we've got trade dress rights that we try to get out. Because we think of trade dress as fashion products or something like that, but it can very much be a product as well, not in the fashion space. And if it's not something where you put a lot of them out, it might even be copyrightable in particular countries. So.
Yeah. I was thinking about inside of our research, we're doing a lot of fluid dynamics testing. We're finding ranges where the technology will and won't work. So the length of the blades in relationship to the inside and outside of the machine, all this sort of stuff, right?
Yep.
I was looking at turning around and making a list of particular ranges that we found that, we can protect. Design and utility patents. Is that something you'd recommend?
Yeah, I think that analysis is helpful. I would try to come at it from a couple of different perspectives and see which different aspects you might be able to protect.
Okay.
Yeah.
Thank you very much.
Sure.
Are there any more questions for Bob? I will put this recording on
Great.
Yeah, I have a quick one. So I've got biopellets for seaweed packaging. Haven't lodged a patent yet, just because the cost is prohibitive. So there's a trade secret and a recipe. So the trade secret in terms of the process. I've been contacted by Unilever and they're speaking with me tonight, but they've given me very detailed questions that they'd like to know about the product, and I think I'm struggling to. Obviously, the motives are concerning as well. I've had some advice that some companies might just want to shut it down rather than support. I don't know how correct that is, but also if I can't commercialize it in terms of put it in the market before I make that decision on the patent, what would your advice be on that? But apparently, if once it's in the public domain, I can't then protect the IP.
So there are grace periods that you have depending on the type of IP and the country. China, for example, for the most part, no grace period. So you'll lose the ability if you publicly disclose or even share it with another company outside of an NDA. You may lose the ability to file a patent in China completely, whereas in some countries it's 6 months or up to a year that you can look back. The US is fairly liberal in that. And sometimes you can work that patent into a liberal filing system first and then try to get back into countries that you would have missed otherwise, but that doesn't always work. It's really country specific. The big warning out there, and I've worked for big companies, I've worked for small companies, it's very, very common for big companies to reach out and find out what small companies are doing, not under NDA, to remove the risk by removing the ability of that company to get a patent on it. Or just to steal it because it's a small company and just to take it and use it. So it happens all the time, and there's litigation about that all the time. So a big warning out there. I don't know Unilever in particular if they're looking to do that with you, but
Thank you.
A provisional patent application, it can be, we sometimes call it a napkin patent, a US term. You can literally write it on the back of a napkin and file it with the name and date information, and it costs very, very little money, especially for a small company. And then you get your provisional date. The problem is the protection you get is limited to what it is you disclose. So it's always better to put more detail in that. But that provisional then stays unpublished, confidential for that year. And if you don't file a proper patent application within that year, you can just let it lapse and keep it as a trade secret. So at least buys you some time. I would just spend a little time talking to somebody up front about how much detail to put in. Because once it publishes, it's out there. There's nothing you can do about it.
Yeah.
That's at the 18-month mark.
Okay.
Hey, Bob, I got a question.
Yeah.
If you have filed a provisional utility patent in the US
Yep.
can you then file a PCT patent?
Yeah.
Yeah.
The-
And you,
Go ahead.
no, I was going to say, and do you get availability of the earlier filing date, or is it not so?
You absolutely, the whole point of the provisional is to make it easier and quicker for companies to put something down on paper and get that priority date. You then have up to a year to file your non-provisional, which is either your standard application or a PCT or both. You can do both. And then the PCT gives you up to 30 to 32 months, depending on the country, after that initial provisional date. So, 12 months less than that if you filed at the 12-month mark, to go into other countries. So it's a very, very useful tool for pushing costs out until you know what countries it's going to be useful to file in, and you maybe have some more money to file in there. But you can turn around to your investors and say, I filed a provisional that will allow me to file a PCT, which will allow me to go into 160 some odd countries. And so I can go really big if I need to. I just didn't need to spend that money right away.
Yeah.
You can file multiple provisionals in that year and put them all into one PCT application. So there's lots of strategy. Yeah.
Is there any advice on patents in India? Is that much like everywhere else in the world, or is there a few nuances?
There are some nuances. When we walk through with our clients where to file a patent, we're looking at where they're going to sell their technology, where their competitors are, where the products move through. So choke points, which can be like China, exporting, Hong Kong. It tends not to be India. It's not sort of in the top 5. It's rarely in the top 10, not because there aren't a lot of people using it, but because it's harder to enforce in India. And slower to enforce and more expensive. So it's on the list, but it's not usually. It's somewhere around top 10 to 20. I would work with a firm that has it. The main advice here is, I think, draft the patent in the country that's the most valuable market for you, because if you draft a patent in Australia for China, you're not going to be drafting it to maximize those rights. So if India is the main place you're going to sell your technology, find a firm that can draft it in India and one that's used to enforcing it. Because I think we do a disservice here in Australia breaking the profession out into people who draft but have no licensing or litigation experience, and vice versa. Whereas if you can find somebody who knows the ins and outs of enforcing the patent, they're going to draft it in a way that's going to be more useful for you for not much of a price difference, if any.
Well, this has been so incredibly helpful, but I do have another meeting to go to, so I'll have to get off this line. How can we grab you a coffee? Whereabouts, or how can everyone get in touch with you? Because I'm sure everyone is eager to explore that.
I'll cycle all the way to the end here, but it's basically just my name, robert.kramer@finnegan.com. It'll be on the slides. I think you put a link in the invite to my LinkedIn. Or you can give me a phone call here. I'm happy to go out. We generally run conflict checks. So if you just give me name, company, general technology, or trademark, or whatever, we run a conflict check so that we make sure we're not talking about your competitors that are our clients. But assuming that's fine, I can meet. We don't get into the privileged information, and most firms won't until you're a client. But there's a lot you could talk about getting up to that point in a general way that can be very useful, I think.
Thank you so much. You've been incredibly generous with your time. For lawyers, I mean, don't you charge by 4-minute increments? So thank you so much. And thank you so much for everyone's engagement and attention, and being such a great audience for Bob. So I'm sure we'll be in touch, because we are taking a cohort to the US, and we'll need your insights on that as well.
Happy to help in that. Yep. Okay. Charlotte, thank you very much.